Good morning, everyone, and welcome to our jurisprudence class. So we are going to look at the part 2 of our topic, legal positivism. Now, just before we come to this morning's topic, you'll recall that at our previous class, we started treatment of legal positivism, having explained generally that legal positivism, in contradistinction to natural law, is that approach to legal philosophy, or the quest to answering the question, the nature or the essence of law, which says that our emphasis should be on what the law is rather than what the law ought to be. So it's more about the empirical reality of the law as opposed to metaphysical abstraction or speculation or supposition regarding what the law ought to be. And we made the point that a number of thinkers have actually made significant contribution towards what constitute the school of thought in jurisprudence that we call legal positivism. So we started with Jeremy Bentham, and some scholars may even say that Jeremy Bentham is probably like the father of legal positivism, having pioneered such thinking. But that is a debate we'll leave for another occasion. And we recall saying that Bentham had actually looked at law in terms of the sovereign, punishment, the principle of utility, greatest happiness for the greatest number of people, and the philosophical calculus and all that. Now, we saw how his approach was crooked in a number of ways, in the sense that it was a lot of rough edges. So subsequently, one of his disciples, or one of his mentees, so to speak, John Austin, will embark upon a major work, which he titled The Province of Jurisprudence Determined, which is one of the great work in what we call analytical jurisprudence, analytical legal positivism. And he would actually take the view that the way that we use the word law, we use it too loosely, in the sense that there are some senses which is not actually the concern of jurisprudence. And as you notice, he did his schemata, in which he did the breakdown of like the various senses in which you deploy the word law, and you eventually say that it is a certain narrow aspect, what you call like the law strictly so-called, which is the domain or the province of jurisprudence. And Austin, we also noted, like his mentor or his godfather, so to speak, Jeremy Bentham, also look at law from the point of view of the sovereign commands backed by sanction. So all of them, Jeremy Bentham, Austin, they are all considered what they call like the command theory of law, because they look at law as a command of the sovereign backed by sanction or punishment. And but we saw that how Austin's look at law was also very limited, in the sense that his theory could not provide a satisfactory explanation for the entire enterprise or phenomenon of law, but only the criminal law aspect of law. And in fact, if you're having to follow Austin to his logical conclusion, he will say that international law, for example, is even not law, because he has looked at it from the point of view of the sovereign. And in his view, there's no sovereign international law whose commands are backed by sanctions. So these were the ideas which we discussed at our last class when we discussed legal positivism part 1. So this morning we are going to look at two important proponents or contributors to legal positivism, Hart and then Kelsen. So Hart, his full name is Herbert Langley Adolphus Hart. A very mouthful, 4 names, or we simply say H.L.A. Hart. Now, H.L.A. Hart was a British legal philosopher. He was based at the University of Oxford, and he is reputed as one of the most important or influential legal thinkers, or if we like, legal celebrities when it comes to jurisprudence of the 20th century. He did a major work which we call the concept of law. And the concept of law is a book which every student of jurisprudence or legal philosopher is familiar with. And that is why, because we are good friends, I've gone to the extent of getting a PDF and sharing the PDF version with you on your platform. Of course, the hard copies are also available in the library. So I encourage all of you to read the whole of the work of Herbert Langley Adolphus Hart's concept of law. It was published in 1961. Now, in Hart's concept of law, he begins his work by reflecting on what he called the persistent questions of law. And so the nature of law, according to Hart, has been a persistent and a complex question in legal theory. So that is how he commences his work. And he acknowledges that this nature of law has generated diverse and often paradoxical or contradictory responses from jurists, that is, various scholars of jurisprudence or legal philosophers. And Hart makes the point that, unlike other disciplines where foundational questions are relatively straightforward, law has resisted simple definition. And we've made this point before. When you are learning history, you'll be told about all the various definitions out there. When you are learning economics, when you are learning science, biology, physics, chemistry, you'll be given some definition which to a large extent will be universally acclaimed. But then when it comes to law, Hart, in this concept of law, we acknowledge that law has resisted simple definition. So the question, what is law, has invited or elicited vast responses, and for that matter, vast literature out there. Now, these responses have different perspectives or different point of view with respect to essence of law, with respect to structure of law, and also the relationship between law and society. And in Hart's thinking, this ongoing debate that is attended by various scholars or thinkers to opine some responses to what is law reveals that law is not only a set of rules or commands, but encompasses broader issues that have become focal points in jurisprudential inquiry. So you notice that right at the very outset of his work, if you look at the chapter 1 of his work, Hart is actually shooting the command theory of law, because he's saying that there are so many other broader issues which have not been factored into the calculus or into the thinking of those who postulate the command or the imperative theory of law. So, Hart identified what we call fundamental questions that confront legal theory. So he identified what he called the orders backed by threats. And here, certainly, Hart was referencing John Austin, who had conceptualized law as a command issued by a sovereign backed by threats of punishment, which we discussed as a topic in our previous class. And as we noted, this command theory actually approaches law in terms of coercive orders or an extension of authoritative commands of the sovereign, which is enforceable through the threat of sanctions or punishment, as it were. So Hart knows that if you look at law from this point of view, then law's essence lies in its power to compel obedience through potential penalties. So you use the phrase, so law become like the gunman at great large, or much like an order issued by a gunman to a victim. That is to say that if you follow the imperative theory, then you reduce law to like maybe somebody holding a pistol, right, in his hand and giving orders, raise up your hand, or don't move, otherwise I shoot, or lift up that thing, otherwise I shoot. You know, the things that you see in action movies, you know, when somebody comes under gun attack. So Hart is saying that if you follow John Austin's command theory and all that, then you are effectively reducing law to an order which is issued by a gunman to a victim. Yes, to a large extent, he acknowledges that that is a reasonable explanation to the branch of the law we call criminal law. As you know, in criminal law, the penalties are clear and forceful, as we know from Article 19 of the Constitution, which says that no person shall be what? Punished for a crime unless the crime has been defined in a written law, the punishment prescribed by it. So that is fine. However, in Hart's view, this approach fails to explain law's broader dimensions, particularly in civil matters. We are talking about contracts, we are talking about torts, and so many other civil law areas, where compliance often arises from voluntary adherence rather than fear of punishment. So people comply not because they're afraid of a punishment of going to prison or paying a fine, but because they have either signed up to something like, especially in contractual arrangement, as it were. Then he also flagged law and morality. And he is concerned that the relationship or the connection between law and morality has also been problematic so far. If you look at the various responses which scholars have given to the question, what is law? So Hart would note that historically, natural law theorists have argued that law derives its legitimacy from its alignment with moral principles. And we've seen this from the various discussions that we did. Now, this contrasts with legal positivism, as we saw last week, which maintained that law and morality are distinct. So law does not need to be morally just to be valid. But Hart will acknowledge that as legal system frequently overlap with moral standards, prohibition against murder, theft, and other social reprehensible behaviors, for example, there is a temptation to see law as intrinsically linked to moral values. In other words, if you look at certain criminalized behavior, such as murder, theft, rape, defilement, unnatural carnal knowledge, especially having regard to Ghana legal system, where we have still criminalized it. Now, if you look at those offenses on their own, there's no doubt that they reflect significantly morality. And because they reflect morality, there's that temptation for us to equate law to morality. So that is a point that Hart is trying to talk about. So he acknowledges that, yes, the ongoing debate, the various responses by various proponents or jurists to the essence or the nature or the structure of law is a reflection of the difficulty we have in trying to distinguish legal obligations from moral obligations. And that in itself raises questions about the foundation of legal authority. Is legal authority drawing its strength from moral authority necessarily? So that can we say that without the moral foundation, then legal authority will collapse? So that is what Hart is inviting us to ponder. And it's important we follow his reflection on this persistent question. What he's trying to do is that Hart is trying to acknowledge that, yes, I'm not the first boy on the block. Before I arrive on the block, there are so many other people. Before I arrive on the scene, other important thinkers have come and have made the noble effort to try and engage the question, what is law? But then, when I reflect on all these responses, I see major pitfalls, I see major deficiencies. And those deficiencies need to be acknowledged before we can chart a new path forward. And in fact, that is a hallmark of proper scholarship. And that is why when you're even doing your research, okay, you're doing your research as a student, you don't just start writing anything, because don't forget that the world has been there thousands of years, or even some scientists will say that millions of years before we appeared. So other thinkers have come. So you need to acknowledge that. And that is why there's what we call the literature review, isn't it? You try to find out what others have thought about whatever you are interested in looking into. And you try to demonstrate that, yes, this is what they have done, but you see some limitation or you see some gaps here. And that will provide the pedestal, or that will provide the platform for you to also mount whatever you are going to do. And that is exactly what Hart is trying to do in the opening phase of his work, when he explores what he calls a persistent question of legal theory. Now, he also identifies the role of rules in law. Now, Hart knows that legal theory grapples with the nature of rules and whether law is fundamentally a set of rules. So is law a set of rules or what? That's what he's pondering. So both the command theory and moralistic views, that is the natural law views, acknowledge that rules are central to law, but they diverge on what constitutes a rule and how rules function within legal system. So what constitute rules, which they all acknowledge as being important, and then what is the function of rules within legal system? For some, legal rules are clear directives that guy behavior. And for that matter, it has intrinsic authority on its own. It has an inherent authority on its own. Others also argue that rules are not absolute and often require interpretation. And this will lead to judicial discretion. So later on, there's a scholar we call Ronan Joaquin. Joaquin will definitely be reasoning along these lines that rules are not absolute. Rules often require interpretation. And because it only requires interpretation, it gives rise to judicial discretion. Courts, when interpreting rules of precedent, frequently face ambiguities, like face situations, face dilemmas, giving rise to more than one possible sense or one possible way of viewing matters. So there's some judicial choices which will have to be made. And that suggests that rules are not self-enforcing or purely objective. In other words, Hart is saying that if you look at rules out there, rules do not enforce themselves. Rules require interpretation. And if for nothing at all, those of us in Ghana, there's a very similarly simple rule in our constitution, in our 1992 constitution, how it has given rise to so much trouble in the whole of the country. And I'm referring you to the Article 97. Let me open my constitution. Yes. Article 97, Clause 1, Paragraph G, which states, and I quote, "A member of parliament shall vacate his seat in parliament, G, if he leaves the party of which he was a member at the time of his election to parliament to join another party, or seeks to remain in parliament as an independent member. Or H, if he was elected a member of parliament as an independent candidate and joins a political party." So you see this provision. What does it mean? You see how it has plunged a country of over 30 million population into various discourses, everybody trying to tell us what he understands by these provisions. And that reinforces the point which Hart is trying to identify, that if you look at rules, they are not self-enforcing or purely objective. Instead, rules exist within a framework where context, that is environment, the surroundings, where context and interpretation shape the application. So that in itself, in Hart's view, highlights a tension between seeing law as a fixed set of rules versus a flexible system shaped by social practices. And, like this particular example that I gave may not be the best example, but at least it helps us relate, to draw some connection between reality and the theories that we are learning. So you look at people who are now appealing to history regarding what has gone on in our parliament since the coming into force of the constitution, what some people have done regarding either people going independent or independent joining political party and so on. People are appealing to that, and others are appealing to travaux préparatoires, legislative history, that yes, go back to the consultative assembly proceedings. What did they mean? What was the backdrop for these provisions. Look at the committee of experts. What did they say regarding this? You must look at the history, or must we also look at what we call the contemporaneous exposito, that we look at the contemporary situations to try and give the exposition to this interpretive matter. So these are some of the matters which Hart is trying to draw attention to at the very threshold or beginning of his work. So he also identified common perceptions and theoretical complexity. So Hart will say that, well, despite the complex theoretical debates going on among jurists or students of legal philosophy, most people can readily identify examples of law, maybe such as prohibition against murder or regulation concerning contracts. And if you look at the point of view or the perspective of lay people as those who are not jurists, you notice that it often aligns with a practical view of law as a system of rules governing behavior within society. So for those who have not actually saddled themselves with too many complications and complexities as legal philosophers would do, but they come to law from the point of view of just like as a layperson as like someone who is not initiated into the nuances of the legal theory. For them, they see law as just a system of rules governing behavior within society. So people recognize that laws are created, interpreted, and enforced by specific institutions, such as the legislature and the courts, and that give law its structure and authority. But Hart points out that when scholars attempt to define law comprehensively, when scholars attempt to adopt overarching explanatory theory of law, then they encounter ambiguities. They encounter ambiguities in the sense that they are not able to get one size fits all, like one definition or one explanatory framework, which will hold valid for all dimensions of the issue. And in fact, there are edge cases, or what we call like the penumbra cases, or what we call the gray cases, right? That complicate these everyday understandings. For example, the example I gave from Ghana, if you look at our 1992 Constitution, Article 97, Clause 1, Paragraph G and H, which I quoted. We have some sort of probably, the matter is sub judice, so very little can be said about that. But just exercising academic freedom and not using any judicial mandate or lens, I mean, it suffices to say that we see some, a bit of like a gray area in the sense that you have people who are MPs. The parliament is in session. On the floor of parliament, as far as what we are reading from the news tell us, there's no evidence that the four affected MPs, whether any of them have actually moved to join a different political party from that on basis of which he was elected, or if the person was elected as independent, he or she has actually joined a political party on the floor of parliament and then in the proceedings and operations of parliament. At least the narrative coming from the media regarding the development in parliament does not tell us that. Now, but then what we know is that these affected MPs, they have officially evinced an intention to run as independent, or if they were elected independent, to run on the ticket of a certain political party. Now, that is a gray area which it presents. Now, the story will be different if, for example, on the floor of parliament, the work of parliament, they have crossed a carpet, as the term is actually used. And that is the penumbra area, the gray area, which Hart is talking about. So then he also mentioned the cases like international law or customary practices, which challenge standard definition because they lack some features typical of municipal legal system, such as central authority or enforcement mechanism. So if you take international law, yes, as Austin also pointed out, and other scholars, that it's difficult to reduce international law, for example, to the working structure and operation of municipal law. As he has just told us, yes, we have the legislature which makes law, we have the courts which enforce them, interpret them, and all that. Now, if you go to international law, it's not that simple, because as you have noticed, even where a treaty is made, depending upon the particular philosophy informing a municipal legal system, a theory which has a treaty which has been signed by a country may not be self-executing. It may not be immediately applicable within the legal system, especially if the country practices dualism, which Ghana is an example. So we have to look at, let's say, Article 75 of our Constitution and all that, where the government signs a treaty, it has to be domesticated by Parliament, as it were, before it will have binding effect within our legal system. But some other municipal systems, that may not be necessary because they subscribe to monism, that when they sign a treaty, it has immediate application. So even within the context of making of law on international play, you see how we have complications, and that is a point being made, that yes, you may not be able to apply the theory that you build on domestic or municipal legal system to explicate the phenomenon of law on the international plane. And again, if you're even talking about this command theory and all that, yes, international law, who is there to enforce it? Look at what is happening now in the world. We have the law against the use of force, that no country can militarily intervene in the affairs of another, except where it's for like legitimate self-defense and so on and so forth. But look at what is going on in the Middle East. Look at what is going on in the Russia and Ukraine. And then we are told that North Korean soldiers are also joining the war. Then people talk about it, but what can you do? So there's no one to actually enforce it. Because if you attempt to raise yourself as a policeman of the world, then other countries may also want to confront you. Like we see United States, which for a long time used to project itself as a policeman of the world, so to speak. How other countries have recently, also sought to resist that by trying to push for the so-called multipolar world as opposed to unipolar world. We've had the times in which we used to have a bipolar world, the East and the West, US and then the USSR. But then the USSR collapsed and I was left with the USA. And after many years, some other emerging powers, Russia and China, also feel that we shouldn't have a world in which we have like one strong country, which behaves like the policeman of the international law. You have like a multipolar world. So this is some of like the evolving debates which is going on. So Hart points out that the debate around law's nature is not limited to identifying its characteristics, but also involves understanding the function of law within society. What is the function of law? What is the rule of law? So some theorists argue that law's purpose is to maintain order through deterrence, while others believe that it should foster justice and social welfare. So you notice that even when it comes to the proper rule of law in society, it's not that simple. There are divergent of opinions, to speak. And these differing opinions on whether law is fundamentally coercive, that is as a deterrent, or aspirational, that is encouraging us what we ought to do, or have the aim of trying to encourage socially beneficial behavior rather than merely imposing benefits penalties for misconduct. So Hart sums it up all that there are three persistent issues in defining law. So having acknowledged the state of juristic thinking as far as the question of what is law is, what people have attempted to do so far, the various natural law scholars, and then the command theories, and so on. Hart will try to problematize the situation and say that there are three persistent issues in defining law. And in his view, if we look at the work of various legal theories, they often return to three central issues, namely relationship to commands. How does law differ from commands backed by threats? So, and is coercion a defining feature of legal system? Is it really correct to insist that if you want to define a legal system without the element of coercion, then you cannot really define legal system? So that is one issue. Then another issue is the moral obligation versus legal obligation. How does legal obligation relate to moral obligation? And with respect to this, Hart raises the issue: can a law be legitimate if it lacks moral grounding? Is the validity of law dependent upon its moral legitimacy? And thirdly, rules and legal interpretation. To what extent does law consist of rules? And how does judicial interpretation affect the stability of these rules? So these are the persistent issues which confront scholars as they attempt to make sense of the nature of law. So these questions to Hartman have shaped much of modern jurisprudence, as each of the three questions you pointed out reveals essential aspects of law's function and structure. But the challenge, in Hart's view, lies in developing a theory that can address these three issues. Namely, the relationship between law and commands, especially the issue of coercion, whether coercion is a necessary component of law. The relationship between moral obligation and legal obligation. Can legal obligation stand on its own without moral foundation? And thirdly, the relationship between rules and legal interpretation. Are rules self-enforcing? Are rules objective so that they can just work on their own? Or there's a need for interpretation to be done? And if there's a need for interpretation to be done, how does that affect stability of the rules? How does that ensure certainty and predictability of rules? So these are the matters which Hart will say lie at the heart of any meaningful effort to try and propound a theory or framework which will explain the enterprise of law. So Hart will proceed by attempting to provide a definition to what is law and challenges which are associated with those efforts or those attempts. So in his view, efforts to define law typically fall short because they struggle to encompass all its aspects. So the reason why we've not been successful in trying to define law is that we try to have a fully self-contained, one-size-fits-all approach. So we try to get like a master, if you like, definition, which would apply, which would address the whole gamut of law as a phenomenon, and that is challenging. So traditional definitions based on rules or authorities, in Hart's view, are often too narrow, and they fail to capture law's dynamic nature and its relationship to social practices. So you give example that defining law merely as a set of rules, defining laws merely as a set of rules presumes that these rules are static and ambiguous. And that is rarely the case in practice. In other words, if you take the view that, yes, law is a set of rules, the problem is that such a way of defining law is making the assumption that the rules do not change. They remain fixed. They are the same. And two, the rules have settled meaning. They don't give rise to more than one or two meaning or understanding. And Hart says that in reality, that is not the case. Law often requires interpretation, especially in areas with ethical implications such as constitutional law or human rights. So you cannot do without interpretation. When it comes to, for example, human rights, let's take Article 17 of the 1992 Constitution. Article 17 of the 1992 Constitution talk about, I think, the rule against discrimination, isn't it? All persons shall be equal before law. Then clause 2, a person shall not be discriminated against on grounds of gender, race, color, ethnic origin, religion, creed, or social or economic status, unquote. Now, I'm just going to give you a very simple but quite deep example, where Article 17 clause 2 says that religion and creed and so on should not be a basis for being discriminated against. Now, when it comes to religion, do we have any standardized definition of what counts as a religion? So that if someone is seeking to profess something, can we say that, no, this one, it doesn't fit our understanding of religion, so we not recognize you as being adherent of that religion you so professes, so as not to be discriminated against? Do we have any yardstick? If you read the case of the Nyameneba from criminal law, remember those who were cultivating the Indian hemp and so on, and they say that, well, they use it for their worship or their way of life. So if, for example, you have a law which says that, yes, Indian hemp or marijuana or cocaine or whatever is a narcotic drug and it is outlawed. And well, somebody says that, well, for our religion, we use it for purposes of incensation. We put it in the fire and the smoke will come and then we hail it. And that is how we are actually worshiping. So you see the difficulty, and it reinforces the Hart's view that interpretation is inevitable. So you need to interpret. So let's say religion in Article 17, it will have to fall for some interpretation at some point, isn't it? If you look at the case of the, is it the Tara, what is the name? Is it, this is a Rasta, Talajun, the Rastafarian boy at Achimota. These issues actually come up every now and again, as it were. And even now, you take Article 17 again, there's a reference to gender, isn't it? That shall not be discriminated against on basis of gender. Now, gender for a long time was seen as binary. Binary in the sense that it's either or, you're either a male or female. But the last 2 or 3 decades, I'm looking at the practices in some other jurisdiction, I've brought up some other possibilities. So what is the position of the law? Is it still the binary, male, female, or what? Yeah, so these are the points Hart is addressing. So some jurists propose definition that focus on law's role in organizing social conduct and distinguishing it from other social norms through its formal structures and enforceability. Now, Hart will say that that is interesting. However, such definitions still encounter difficulties, especially when addressing edge cases, gray areas, penumbra areas, like international law or customary practices, which do not fit neatly into standard legal categories, but still perform similar regulatory functions within societies. So if we take like customary law, for example, if we take Article 11 of our Constitution, what is customary law? Rules which by custom are applicable to particular communities in what? In Ghana. So how do you even identify that customary law has crystallized regarding a particular matter in a particular community? So having considered the efforts which have been made by various scholars to try and define law and the shortcomings associated with that, Hart says that there's a need for a break. There's a need for a fresh start. So there's a need for a nuanced understanding, a more detailed understanding. So rather than seeking a strict definition, some scholars argue that legal theory should focus on understanding law's central elements. So its structures, norms, and functions, without insisting on any rigid classification. And that is why Hart, in his concept of law, would suggest that a legal system can be better understood by analyzing the interplay of primary and secondary rules. And these primary and secondary rules, so we tell like the primary rules, they govern behavior. And then the secondary rules, they establish mechanisms for creating, modifying, enforcing laws. And that is why Hart will go on and say that A legal system, properly understood, is a union of primary and secondary rules. So this approach of going about the matter, in Hart's view, allows for flexibility and is also an acknowledgement that law is not merely a set of commands or moral directives, but a complex institution that evolves with society. Law is not static. Society is not static. Society is in flood, is dynamic. And law must also follow suit. So Hart makes the point that when we examine law's structural components and its relationship to coercion, that is force, and also morality, in that way, legal theory can make progress toward a more comprehensive understanding, which reflects law's multifaceted nature. So law is not unidimensional. Law has not only got one aspect. Law has got so many aspects, so many facets. And it is only where we examine law structure vis-a-vis the relationship between force and morality that we can appreciate this multidimensional or multifaceted nature of law. So this view, in Hart's opinion, recognizes that law's authority arises from its acceptance by society, not from its alignment with moral principles or its capacity for enforcement. So he's gradually gravitating to what they call his separation of law and morality thesis. So to Hart, law, considered in this way, is a social institution shaped by and responsive to human values and needs, continually balancing order, justice, and individual rights. So that is, in a nutshell, if you look at law from this broader, perspective, what you see it to be. It's a social institution, yes, and this social institution is not neutral. It is rather dependent on human values, human needs, and it seeks to strike a balance between order, justice, and rights of individuals. So what is the takeaway on persistent questions of defining law by Hart? The takeaway may be stated as this, that the question, what is law, has remained unsolved for a long time, and even not just up to the time of Hart. And we will say that beyond Hart, it's still not solved, due to law's complexity and the varied functions that law performs. So on that basis, how to say that why lay perspective, when we say lay perspective, that is those who are not jurists. Why non-jurist perspective often focus on practical examples, as we saw. Legal theory, on the other hand, delves into fundamental issues, which is to review law's multifaceted nature. So to Hart's mind, in order to address these issues, there's a need for an approach that transcends or go beyond simple definitions, which will recognize law as both a system of rules and a social institution So law is a system of rules and social institution which is intertwined with morality, authority, and societal needs. Now, if you use this broader or nuanced approach in understanding law, it has the advantage of illuminating or helping us to appreciate the law role within society. That law is not a static entity, but a dynamic process. Law does not stand still, just as society does not stand still. Society is ever changing. And if society is ever changing, then law also adapts to the changing social values and expectations. Yeah, so having discussed these general issues in the opening of his work, Hart will go on to try and look at how Austin's command theory has given rise to what he is talking about. So Hart has already talked about the fact that law should be seen as a system of what? Of rules. So he identifies primary and secondary rules. And this categorization of law or being rules in the primary and secondary rules reflects Hart's view that legal systems consist not only of behavioral directives, but also of rules that regulate the structure and operation of the legal system itself. So legal system does not only tell the citizens or the people what they have to do or what they don't have to do, but it also tells us about the law telling us what to do or what not to do. How is that law changed? How is that law interpreted? So now let's say a few words about the primary rules. When Hart talks about primary rules in his concept of law, these are rules that impose duties by prescribing or prohibiting specific behaviors, and they serve as fundamental norms that regulate conduct within a society. So example of primary rules will include prohibition against theft. So look at section 120, 121, 122, 124, the offense against stealing, dishonest receiving, and so on. The offense against the falsification, forgery, rape, defilement, murder. These are all examples of primary rules. Or when it comes to contracts, the rules on elements of, let's say, a valid simple contract. You need offer and acceptance. Offer and acceptance, and need to be supported by consideration, except where consideration is excused by specific provisions of the Contract Act, 1960 Act 25. Or you come to the law on defamation in tort, that you are not supposed to publish false information which will lower the reputation of another person within the estimation of right-thinking members of the society. So these are all examples of primary rules. And Hart argued that these rules are necessary, but they are not sufficient for a developed legal system, because primary rules alone cannot address all contingencies or changes, ambiguities. So if you have primary rules which tell us what we should do and what we should not do, that is fine. But according to Hart, even primitive society, societies without sophisticated legal system, they all have that. So that alone is not enough. You still need something more before you can have a fully developed legal system. So I'll give you like an example. Now let's take, if we take, let's say in UK, for example, for a long time, unnatural carnal knowledge was a serious criminal offense. In the course of time, it's no longer offense. So you see the primary rule has changed. So how did the change in the primary rules come about? There must have been another rule which governs how changes can be made in the primary rules, or if there are ambiguities in the primary rules, how they can be interpreted and all that. Or you take the offense of, let's say, attempted suicide. In our country, Ghana too, it was an offense. But just I think within the last 2 years, it's no longer an offense. So there has been a change in the primary rule. So another law, Parliament will go through the legislative process. Article 106 and all that will be invoked. Then you're able to bring about the change in the existing primary rule. And that is why Hart is saying that the primary rules alone are not enough. You need something else. So that provides the basis for his suggestion that to overcome if you read his work, he will make the point that to overcome the fact that primary rules are not static, they will need for a change, they will need for interpretation and all that, then you need secondary rules. So the secondary rules, so-called secondary, because they are rules about rules. So the secondary rules are rules about the primary rules. So they provide the framework for creating, modifying, interpreting, and enforcing primary rules. And these are essential for function of a complex legal system. So you take, I give you a typical example. You take the Evidence Act of Ghana, 1975, NRC Decree 323. And then that legislation is supposed to tell us how evidence may be received to prove or disprove an allegation. So that is not a primary rule, that is a secondary rule. Because if you are, for example, alleging that someone committed stealing, you need to bring evidence to establish the guilt of the person beyond reasonable doubt. Now, what is acceptable in proving the guilt and what is not acceptable? You need another rule to help us to determine that. So, for example, the Supreme Court decision in Raphael Kubajel will tell us that as a general rule, where you secretly recorded the person without letting the person be aware, that recording may not be admissible as a valid or good evidence in a proceeding. Maybe except where you can bring yourself within some exceptions, like maybe prevention of a crime and so on, maybe such as maybe terrorism and so on. So these secondary rules, according to Hart, address the limitations inherent in primary rules. So the limitations we saw, like the fact that the primary rules may be static, the primary rules may be inexact in the sense that they may need to, you need to determine whether it covers a particular situation or does not cover a particular situation, which calls for interpretation. So the secondary rules actually address the limitations inherent in the primary rules by enabling flexibility and adaptability within the legal framework. So there are three essential types of secondary rules, according to Hart. These are: one, rules of recognition. So rules of recognition is a subset of a secondary rule, and they serve as a foundational standard within a legal system, as they provide a criteria for legal validity. Now, in other words, we need a yardstick to help us to understand which form part of the primary rules and which does not form part of the primary rules. So, the rule of recognition allows society to distinguish valid legal norms from non-legal social norms or customs. And on that note, it acts as a benchmark for legal authority and determines what is recognized as law in a given society. So a typical example is Article 11 of our Constitution. If you look at Article 11 of 1992 Constitution, this is what it says, and I quote, or maybe you can start from the chapter 4, which is headed the laws of Ghana. The Article 11 says that, quote, the laws of Ghana shall comprise A, this constitution, B, enactments, C, any others, rules and regulation, D, existing law, and E, the common law. Now, so if anything is being put forward as a law in Ghana, we must be able to subsume it under one of the various sources of law adumbrated in Article 11, which I just quoted. If it cannot be subsumed under any of those categories, then it is not part of the laws of Ghana, so to speak. And that is what the rules of recognition is telling us. So it helps us to know that which forms part of the valid legal norms and that which does not. The rules of change. These rules authorize individuals or institutions to create, modify, or repeal laws. So they enable the legal system to adapt to evolving societal needs, changing values, and new circumstances, and that ensure that laws remain relevant and effective over time. So if you take our Constitution again, you take Article 106 of the Constitution, it tells us how laws are made. So we use the same procedure for making laws to also change or amend law. So Article 106, for example, becomes like an example of the rules of change. And again, if you look at the, I think chapter 20, chapter 25, the amendment procedure. Let me look at my Constitution. Yeah, chapter 25, amendment of the Constitution. So we are told, if you look at Sowa's famous dictum in the landmark case of Tufo versus Attorney General, that the Constitution of ours is not a static document. It is dynamic. It's a living organism. It mirrors the aspirations and fears of the people and so on and so forth. And that we need to keep adapting it. We need to keep making it be relevant to the evolving needs of society. And that is why the framers of the Constitution, in their wisdom, have actually provided in chapter 25 of the 1992 Constitution that, yes, the Constitution can be amended so long as you bring yourself within the amendment procedure. So we have entrenched provisions. So if you look at Article 290, that this article applies to amendment to the following provisions, which are in this Constitution referred to as entrenched provisions, then they are listed. Then we also have amendment of non-entrenched provisions over there. So if you look at the Article 291, it provides the framework for amendment of the non-entrenched provisions. So all these are examples of the rules of change, secondary rules within Hart's concept of law. Then the third secondary rule is the rules of adjudication. According to Hart, these empower courts and other legal institutions to resolve disputes and interpret laws. So rules of adjudication establish the procedures for judicial decision-making and grant specific individuals authority to enforce and apply the law. So if you come again to our legal system, we have our court structure. The Constitution and the Courts Act set up the court system, the hierarchy of the courts, superior courts of adjudication, Supreme Court, Court of Appeal, High Court, the lower court or the inferior courts, circuit courts, district court, and other adjudicating bodies, like the judicial committees of the House of Chiefs and all that. So these are all as a result of the rules of adjudication. And again, when it comes within the courts themselves, apart from they being set up as institution, how do they function? How do people bring their cases within the court? We have rules which govern that. So if you are talking about the Supreme Court, you want to take your case there, you should be able to get the appropriate rule, which will enable you to do that. So we have the Supreme Court rules, 1996, year 16. So if you look at the long title to say that in exercise of the powers conferred on the rules of court committee by Article 33, Clause 4, and Clause 3 of Article 64, and Clause 2 of Article 157 of the Constitution. These rules are made. Then they will tell us about the various things which one needs to pay attention to if you want to bring a case to the Supreme Court. Again, if you want to bring a case to the Court of Appeal, we also have our rules. So the same, so we have the Court of Appeal rules, 1997, CI 19, as amended. So in exercise of the powers conferred by the rules of court committee by Article 157, Clause 2 of the Constitution, these rules are made in that order. Now, if you come to like the High Court too has got its own rules. What you call the High Court Civil Procedure Rules 2004, CI 47. So again, if you read the long one, in exercise of powers conferred on the rules of court committee by Clause 1 of Article 33 and Article 57, these rules are made. Again, if you go to the district court, the district court, we have the district court rules of 2009, CI 59. It's also made by the rules of court committee. And not only that, then we've also mentioned the Evidence Act. The Evidence Act is also part of the rules of what? Adjudication. And not only that, we have the Interpretation Act. The Interpretation Act 2009, Act 792. So if you read a long title of the Interpretation Act, for example, it reads, "An act to revise and consolidate the law relating to the operation, construction, and interpretation of enactments and for related matters." So if there is ambiguity, or if you want to know the meaning of any word which is not ordinary used in any enactment, your first point of call is the Interpretation Act. You have to look at the Interpretation Act. Good. So I mean, we cannot, actually disagree with Hart with these secondary rules of secondary rules, and they allow us to have law to be properly organized, systematically developed, and also adapted to social and political context of a given society. And again, refer you to the to force decision and the dictum of Justice Soa. Yeah, so the rule of recognition, which we have talked about within Hart's work, is quite fundamental in understanding legal authority and validity. The rule of recognition, well, it will say is not the written law, but the fundamental criteria within a society that validates and legitimizes legal norms. It is a rule that enables citizen officials to identify what counts as law. But as you notice, in a more developed modern legal system, you definitely have the rule of recognition be in some form of writing. And that is what we have endeavored to do by giving instantiations or examples from our legal system, Ghana. So in Hart's framework, the rule of recognition has two essential functions. That is one of validation and then the unity. Validation establishing legal validity of norms within the legal system. And we've given various examples. The supremacy of our Constitution, for example, if you look at the Article 2 of the Constitution, and also Article 1, Clause 2 of the Constitution, and then you look at the Article 11, which I will mention. It also serves the function of unity. It provides a unifying standard within the legal system, and which is essential for maintaining coherence and stability. The rule of recognition to Hart also relies on the acceptance of officials who enforce it. So you argue that a legal system exists only if there is widespread adherence to the rule of recognition among legal officials. And this shared acceptance is what underpins the authority and legitimacy of the law. And that is why, I'll give you an example from what is going on in Ghana. That is why some people will say that if Parliament, for example, decide to ignore the Supreme Court, then they have put themselves on the trajectory of collapsing Ghana's democracy. And everything we are doing in Ghana is actually useless, because if the various organs would like to disregard primary allocation of mandates, then there's no point of having democracy. We should as well let whoever can take over the governance of the country take it over, because democracy has failed. And that is why, no matter we may disagree with, of course, as judges, you even sometimes give a decision, but you need to be true to your judicial oath. Look at the laws of the country and the evidence before you. And in your heart, you may not necessarily agree with it, but it's not your heart which is deciding the matter. It is what the laws of the country that you have sworn to do. And then the evidence that you have before you is telling you which you are following. So it's not your private opinions, it's not your religious convictions and all that, which you are doing as a judge. If you wanted to do that, then you have to go and do some other job. But for fidelity to your judicial oath, you look at the laws of the country. As by your training and understanding, you understand it. And then look at the evidence, and then you apply your mind to it, and you reach one determination or another. So that is the quintessential aspect of adjudication. But that being the case, decisions will come, which equally brilliant legal brains may disagree, and that is fine, because we don't have perfection among human beings, and society is not perfect, and our organs and people who man them too are not perfect. That is how it is. But then, if, for example, we have a situation where, just like what we had at the during Bouzier's time, Salah, remember the famous Salah was Attorney General, and then the early morning broadcast when the Prime Minister at the time actually had the broadcast to try and castigate the court for giving a decision which his government disagreed with. I mean, that is actually a low moment for democracy. You take the United States, for example. Biden had a certain initiative, and that initiative was actually struck down by the Supreme Court. Yes, Biden was not happy with it, but all that he could do was to hope that there could be some changes to how the Supreme Court is actually constituted, their duration and all that. But those things are just his wishful thinking, or his desire he would like to fulfill in future if the society will accept it. But doesn't mean that he's saying that I will not obey or follow what the Supreme Court said. No. So I think that that's the same point that we should note in our country. Yes, otherwise democracy collapses. And that is why Hart is saying that the legal system exists only if there is widespread adherence to the rule of recognition among legal officials. So just like judicial precedents and all that, the various levels of court have to acknowledge if there's a binding precedent. If it cannot be distinguished from the case before them, then it's binding, regardless of the fact that they don't agree with it, because of the rule of what? Recognition. And then the various laws which we have set the parameters, the boundaries, the margins of what can be done, what cannot be done. All those things must be respected by officials. But as Hart says, if officials decide not to adhere to the rule of recognition, then that will be the collapse of the legal system. So it is this shared acceptance that underpins the authority and legitimacy of the law. Because all of us accept that we have supremacy of the Constitution. All of us accept that we have the laws of Ghana, we have the various rules and procedures, we have the institutions. Those are the things which give legitimacy to the law. So, my dear students, I would like to advise you, some of you may want to become politicians, or some are politicians. When we are speaking about legal matters all the time, because of your training as a lawyer, speak as a lawyer. Don't speak from political coloration. Whether you are NPP or you are NDC or you are Afro-Franto or whatever, we don't care. What we care about is the law. So we are not lay people, we are legal people. So the rule of recognition demonstrates has shift from viewing law as external commands to understanding it as a social practice that requires internalization of rules by those within the legal system. So two points have come up, the internal and external point of view. So that's another thing that Hart discusses in his concept of laws. Let's quickly say a few things about it as we gravitate towards the conclusion of his concept of law. Now, Hart introduced the internal and external point of views to distinguish between those who see law as binding and those who observe law without commitment. So these perspectives are important because they provide insight into how individuals interact with and perceive legal rules. So what does it mean by the internal point of view? The internal point of view is held by individuals who accept law as binding and view it as a standard of conduct. For them, legal rules are normative. That is, they impose obligation and create expectation. That is why we say that they are normative. They impose obligations and create obligations, create expectations. Now, those who adopt the internal perspective or point of view recognize legal rules not just as external commands, but as guiding principles that they voluntarily follow. It's not like somebody, imposing something on you, but something that you have internalized. For example, if you read his original work, he used the, let's say, the traffic light example, okay? The traffic light, when it is red, we stop. When we stop not because we are thinking that the police will arrest us or the camera. Maybe to some extent for some people, but by and large, that is not really the point. That I have to say that we have internalized, we have become so accustomed to that, it is weaved into our fabric that we accept it as the proper way to behave without even questioning it. So that is the internal point of view that he's talking about. And not that maybe there's a policeman hiding somewhere, ready to probably issue a ticket or arrest. So this way, that is the internal point of view in Hart's thinking, is essential for the function of a legal system, as it reflects a sense of obligation among citizens and officials. So let me give you an example. We have the executive arm of government, right? If you look at Article 58 of the Constitution, the executive authority has been given to, let's look at Article 58 of the Constitution. 58. Can somebody read it? Okay, so if you look at Article 58, it says, and I quote, "The executive authority of Ghana shall vest in the president and shall be," okay, James Cole's hand is up, okay. James, read for us.
Yeah, my lord, yeah. Article 58 of the Constitution 1992, Clause 1. The executive authority of Ghana shall vest in the president and shall be exercised in accordance with the provisions of this Constitution. Clause 2. The executive authority of Ghana shall extend to the execution and maintenance of this Constitution and all laws made under or continued in force by this Constitution. Clause 3. Subject to the provisions of this Constitution, the functions conferred on the President by Clause 1 of this article may be exercised by him either directly or through officers subordinate to him.
Okay, all right, thank you. Please jump to Article 181. Article 181. Let me see. No, let's even start from, I'm just giving certain examples. Let's start from 1741. Just 1741. Then when you finish, yes, 1741. Please pay attention.
1741. Okay. Article 1741, Clause 1. No taxation shall be imposed otherwise than by or under the authority of an act of parliament.
Okay, so hold on, don't lock your mic. You see, we cannot run a country without public revenue. That is from taxation. But we are being told that when it comes to taxation, It is only by act of parliament that it can be levied. Yes, you are elected the president. You have the executive authority by virtue of Article 58 that we saw. You appoint ministers to help you and all that, and they're all working for you. But you know, the president and his government cannot start collecting taxes without act of parliament. The president and his government cannot waive or forgive taxes without act of parliament. And that is why Hart is saying that the internal point of view is essential for it reflects sense of obligation among citizen officials. Yes, look at recently when Parliament adjourned indefinitely. You see how the ruling party is pushing hard to try and get Parliament to be recalled. Why? Because if Parliament does not go into session, the function of government to a large extent will come to an end. When it comes to loans, when it comes to so many other things, certain appointments. So look at Article 181, for example. Article 181 clause 1.
Article 181 clause 1.
Yes.
Parliament may, by a resolution supported by the votes of a majority of all the members of Parliament, authorize the government to enter into an agreement for the granting of a loan out of any public fund or public account.
Now go to clause 3.
Clause 3, 181 clause 3. No loan shall be raised by the government on behalf of itself or any other public institution or authority otherwise than by or under the authority of an act of parliament.
Good. So all these provisions, tell us that the authority of government cannot be exercised meaningfully without Parliament making the appropriate laws or passing the appropriate resolutions, as the case may be. And it's also part of like the point of the part of the internal point of view. So officials should actually recognize that they have limitations. They need to depend on some other institutions before they can function. So just imagine if we have a governmental system where the executive can just go and take any loan at all. They don't go to Parliament for legislative approval and blessing. Then what it means is that the provisions of the Constitution are actually what? Ignored. So if the provision of the Constitution cannot be ignored, in the same vein, if you have a provision of the Constitution says that it's the Supreme Court which is supposed to interpret law and tell us whether something is within or outside the remit of the letter and spirit of the Constitution, why shouldn't that be respected? Now, external point of view, Hart contrasts that with the internal point of view we just discussed. So by this, it means the external perspective of an outsider who observes the law without regarding it as binding. So from this standpoint, law is viewed objectively, and compliance may appear to be based on external pressures, such as the threat of punishment, rather than internalized obligation. So you see the difference. So the internal point of view, yes, officials and citizens have a sense of the law binding just within them, and they are not looking for anything outside themselves before they will give obedience to the law. So Hart says that this external viewpoint, why it can describe the actions of those who comply out of fear of sanction. It does not capture the normative force that legal rules have over those who generally accept them as binding. Yes, if you read later on when we are doing American legal realism, right? Oliver Wendell Holmes will make the famous statement, what they call the bad man's prediction theory, that the bad man does not care what the law says. What he cares about is that what will be his punishment if he does not obey the law. So that is the bad man's prediction theory of law. That is fine. But Hart is saying that it's not all the time that we have citizens who would like to obey the law because of fear of punishment. But to a large extent, there are many situations in which citizens have just internalized the need to obey the law, and that is why they obey the law. And that is why he says that the external point of view will fail in explaining that aspect of obedience to the law, those who have internalized it. Now, Hart also has his take on the law and morality relationship, his separation thesis. So Hart makes the point that there's a need to separate law and morality. And in his work, we call that the separation thesis. So he argued that law and morality are conceptually distinct. They are like two different streams, each in its own channel. And that means that a law does not require a moral foundation to be valid. The law is valid without the moral foundation. And this contrasts sharply with natural law theories, which we have seen are said that laws must reflect moral values to be legitimate. Now, in Hart's view, a legal system can contain morally objectionable laws and still function as legal system. In other words, we can have laws which are violent according to our sense of morality, but that will not let them lose their quality or their status as law. And that is the heart of his separation thesis or separability thesis of law and morality. So you give example, laws that discriminate based on race or gender may be unjust, but still hold legal authority if they meet the criteria established by the rule of recognition. So for example, if we take slave trade, those of you who have been following the international news, you notice that the Commonwealth had their meeting not too long ago, just this week. And the Commonwealth are like the former British colonies. They have been mounting pressure on their former colonial master, United Kingdom, that they should pay reparation or compensation for slavery, which they engage in the slave trade. And if you monitor the news, the British have also, to use a Ghanaian we were speaking, they've thought about the matter. And then both the Prime Minister and the King, they have resolved and given indications that Britain is not going to pay any compensation for any slave trade that they did. Of course, legitimately, so if they were to do that, I'm sure it will lead to the whole of Britain will become bankrupt. Because if you look at the number of slaves and the atrocities and the wickedness which were perpetrated during the slave trade, I'm sure that if we even value the entire assets, they may not be enough to be able to pay for that. And that is why the leadership of Britain, in their wisdom, decided to run away from the issue. So it makes sense in that way. But of course, previously, I think that they have apologized many years ago about that. But the issue of compensation is a new thing. So just talking about that, at the time they were doing the slave trade and all that, there were certain laws which were passed by either the British Parliament, yes, and then or the King giving order in council commands and so on, which enable certain things to be done. So such law, certainly you notice that it's against morality. How can you, for example, have a policy or law which says that you can sell another human being and all that? But Hart is saying that if having such a law, yes, appears to be unjust, but still has a legal authority if it meets the criteria established by the rule of recognition. If, for example, assuming its parliament has made it, it came from parliament, that is it, it meets it. Just like you look at the, let's say, during the military regimes, or not even the military regime, look at the first Republican Parliament of Ghana. The various deportation orders, Ladan number 1, number 2, Kaftan, and all those, if you remember, where, Kroboduse, Kojibusu, and the rest will go to the parliament for parliament to pass a law. And the law is just for one person to be deported from Ghana. And even if the person is challenging the matter in court, and the court is agreeing with the person, to get parliament to pass a law which override what the court is saying, effectively insists that the person should be deported from Ghana. I mean, such a law on the face of it is unjust, is immoral. However, according to Hart, so long as it satisfies the criteria of the rule of recognition. Rule of recognition says that was it made by parliament? The parliament followed the appropriate procedure for making law. And that also brings to mind the recent Supreme Court decision in the Osebonsu, I think against Attorney General, in which Parliament struck down the Citizenship Amendment Act, which sought to include some offices as being capable of being held by those who hold dual citizens, including the Supreme Court. And as not being capable of being held by those who hold the dual citizens, including Supreme Court. And then the Supreme Court said that, well, yes, Parliament has the power to make the law, but if you look at that law they made, it has the effect of amending a certain provision of the Constitution. And if you look at Chapter 25 of the Constitution, it has provided the various framework for amending the Constitution, depending upon whether it is entrenched or not entrenched. And having regards to this Amendment Act, Parliament did not actually follow the procedure for making the law. And for that matter, the law was struck down as being unconstitutional. So that is another example of what Hart is telling us regarding the fact that, yes, you can have a law which appears immoral or unjust, but it's still law so long as it meets the rule of recognition. So Hart's separation thesis allows legal system to be evaluated independently of ethical consideration. Nevertheless, Hart acknowledges that many legal systems incorporate moral principles, especially concerning fundamental human rights. So if you take Chapter 5 of our Constitution, for example, if you examine Chapter 5 of our Constitution, the fundamental human rights and freedoms, you notice that to a large extent, they reflect morality. And not even the Chapter 6, the directive principles reflect a lot of justice and all that. So that is fine, but that in itself does not mean that if the law does not have that moral appeal, it will lose its status as law. So that's what Hart is telling us. So on that note, Hart is acknowledging that, yes, morality influences the law. That notwithstanding, legal validity is a matter of social acceptance rather than moral correctness. So if socially officials and citizens accept it, then that is it, regardless of whether it is morally correct as it were. And that explains why in some countries, in the US, for example, as we speak now, they put abortion as in some, it's about 10 states. I stand to be corrected, but if the last time I checked the news, about 10 states within the US, as part of the general election that they are having, they are going to vote on whether abortion should be permitted or should not be permitted under their respective state, following the Dobson case, which was decided by the U.S. Supreme Court, that the issue of abortion should be decided by the various states rather than the federal government. So if you look at this Hart's separation thesis, you notice that it's actually a good representation of legal positivism, because legal positivism attempts to draw a distinction between legal and moral obligation. Now, later on, there's a scholar called Fuller. Maybe as part of this, we will do what we call the Hart-Fuller debate. After the Second World War, certain developments occurred, and Fuller will write, trying to ridicule those who subscribe to legal positivism, including Hart, that the law is valid, even if it doesn't have a moral content. Then Hart will later on reflect on all those criticism and come back to make a certain concession that, yes, it's necessary to have a certain minimum content of natural law, because human beings, we have certain limitations or weaknesses, that if we are not to be a suicide club, and we need to survive as a society, then we need to have certain minimum content, such as there should be prohibition against violence and theft and all that. Now, Hart also touched on the open texture of law and judicial discretion. So he introduced the concept of open texture of law to address the indeterminate nature of legal language. The legal language is indeterminate in the sense that it doesn't have exactitude. It has inexactness. So by open texture, he was referring to the inherent vagueness and flexibility in legal language, which prevents law from covering every possible scenario or application. I'll give you a typical example. When you use the word rights, right? Or even the word possession. Possession has inherent vagueness in the sense that it can mean so many things. So if you use like the word possession in the law, what exactly are you referring to? And the indeterminacy of legal language requires judges to exercise judicial discretion in cases where application of a rule is ambiguous. If a rule can be applied in more than one way, then a discretion will have to be exercised by the judge. And Hart will give example. If you take like the term reasonable, okay, which you often see in various legal texts, and as well as if you're doing like the law of tort, like reasonable care or criminal law, reasonable doubt. In all, you see the word reasonable there. So the reasonable doubt, for example, we see in the reasonable care. Does it mean the same as the reasonable we see in the reasonable doubt? Certainly, we have ambiguity. We have indeterminacy. We have vagueness, fluidity, which we are encountering. So such terms in Hart's thinking leave room for interpretation, because what is reasonable may vary depending upon the context. And that is why we later on be told that words are like are chameleon hued, or words sometimes behave like the chameleon. You know the chameleon, it assumes the color of the environment. Some words are like that, and even in law, depending upon the context in which they are being used, the meaning may change. So Hart argued that this flexibility is essential because it allows the law to adapt to novel situations that original drafters could not foresee. When it comes to making laws, lawmakers cannot provide for all scenarios. Just like Article 97, Clause 1, G and H of the 1992 Constitution that we talk about. When the Constituent Assembly, the framers of the Constitution, when they put those provisions there, what did they mean? Did they also mean that if people were serving in Parliament, and in the Parliament that they are serving, they haven't actually physically crossed carpet, they are still doing the usual thing they are doing. But then outside Parliament, they've gone to file paper who says that they are no longer going to contest for re-election on the ticket of the parties which elected them to be in the current Parliament. Should that be understood as covered by what Article 97, Clause 1, G and H saying? So that is the kind of thing Hart is inviting us to ponder, because the original drafters could not have imagined all the scenarios. So there's definitely a need for judicial discretion and interpretation. Now, the open textual aspect of law necessitates that judges have the authority to interpret laws based on context and purpose, which introduces a degree of what? Of subjectivity. And his acknowledgement of judicial discretion served as a counter to the criticism that positivism is too rigid and fails to account for the interpretive role of judges. So later on, when we are encountering scholars like Ronald Dworkin, his Lost Empire and his Right Answer thesis, Ronald Dworkin will be castigating a certain version of a legal positivism, including Hart, and say that if you insist on strict fidelity to the law, then you are not taking care of the interpretive role of judges, which is inevitable as far as the legal system is concerned. But then Hart says that, well, that has been taken account of by his recognition of judicial discretion. So by recognizing open textual, Hart demonstrates that legal positivism is compatible with realities of judicial decision-making and the evolving nature of law. So just before we leave Hart, we need to acknowledge that when it comes to legal theory, as we have stated, no legal theory is perfect. And in fact, human beings, we are not perfect. So everywhere we have we have a criticism. So Hart's legal positivism has also faced various criticism, including leading scholars like Fuller and Ronald Dworkin. Fuller, in criticizing Hart, argued that law inherently contains a moral dimension, and that a legal system cannot function without a commitment to certain procedural principles such as consistency, fairness, and transparency. I hope you remember what we said about Fuller when we were learning natural law, his so-called procedural approach to natural law. When he said that, yes, for law to serve its purpose, which is the purposeful enterprise or subjecting humans' conduct to regulation, then it must have certain elements: consistency, fairness, transparency. So Fuller is saying that law must fulfill these principles to be genuinely authoritative. And if we look at his work, The Morality of Law, he talked about the inner morality of law. And the inner morality of law, he argued that procedural justice is necessary for a legal system to be valid. And this is a contradiction, or it contradicts Hart's view, as we have seen, because Fuller will see legal and moral obligation as being inseparable. For us, Hart has told us that there's a the concept of morality and then the concept of legal obligation are quite distinct. Dworkin, on the other hand, will criticize Hart positivism by arguing that legal principles are as important as legal rules. So it's not all about rules, but we also need principles. Now, he introduced the idea of principles by which he meant that they embody values like fairness and justice, and that they play a fundamental role in judicial decision-making. And later on, when we are learning about Ronald Dworkin's theory of adjudication, his laws empire and all that, he talk about the fact that how in hard cases, that is those cases which are not governed by any particular readily available legal rule, they can still be resolved by the judge by falling on the underlying or the underpinning values of the legal system, which by his training, he's very familiar with. Now, Dworkin contended that Hart's rule-based framework overlooked the importance of principles, which he saw as essential in interpreting and applying law in a just manner. Of course, later on, Hart will come back and also rebut or refute their criticism, and Hart will maintain that, yes, principles can guide legal interpretation, but they are not necessary for a system to be classified as law. And Hart will maintain that legal system could function without incorporating moral principles. But as we saw in his minimum content of morality, Hart will eventually acknowledge that many systems naturally incorporate values of what? Of fairness and justice. So we've spent a lot of time on Hart, so we will actually draw the curtain down so that we have a break and we come back to company law, so that at our next class we use about 40 minutes to discuss Hans Kelsen, and we'll start taking the presentations which you have been assigned. But if you have like questions, I'll be happy to take them. Yes, Father, I'm concerned.
Yes, thank you. But my Lord, please, I would like to know, since in discussing about Jeremy Bentham, you talked about he looking at the command theory. And then here is the case where Hart is departing or shifting from the external command theory. And then he's propounding secondary rules which acquire their legitimacy through especially making, which makes him mention, he doesn't make mention of any sovereignty or an external rule. So how does he validate the secondary rule? I'm talking of this legitimacy because of the same which applies to the statement of recognition here, that if a rule of recognition is outside the legal system, then it may lack legal authority. Yet, if it is inside the legal system, it would also require validation by another rule of recognition. So would this not lead to an infinite regress or a vicious cycle in this theory?
So you are being influenced by the thinking of Hans Kelsen, which we'll be discussing later on, by his hierarchy of legal norms, where each legal norm derives validity from the succeeding norm. But what Hart is trying to tell us is that he's not disputing the relevance of command theory, but his problem is that if all that we had was the command theory of law, as espoused by Jeremy Bentham and later on John Austin, then we will hit a deadlock. We will get to a stage where we cannot explain so many other aspects of law, so many other aspects of the legal system. And that is what he sought to do. Yes, when it comes to criminal law and all that, perfectly, he agrees that the command theory provides satisfactory account. But from your learning of the law, the past 3-4 years, you will notice that criminal law is just a fraction of the law. And there are so many other areas of the law which is not criminal law. So how do you explain the law of succession, equity and trust, the law of wills? How do you explain all that? Contract, tort, land law, intellectual property. They are not, they don't follow the pattern or the framework of criminal law. And that is where he thinks that we need other way of explaining the legal system as a whole. And then he will say that, yes, in every legal system, we have rules who tells us what we should do or what we don't have to do. And even in undeveloped legal system, he uses the expression primitive society. We even see it over there. And you call that the primary rules. What do you call like the do's and the don'ts? But then he makes the point that the do's and the don'ts cannot help us to understand law completely or legal system completely, because it's not everything about law what's necessarily about our direct behavior. But sometimes we also have laws which help us to understand the laws which regulate our direct behavior. And that is why he will bring the idea of like the secondary rules. And the secondary rules, he talks about like the rules of the, among other things, the rules of recognition. And the rules of recognition help us to know the legal norms that form part of the legal system and that do not form part, which officials and citizens actually recognize. And that is why he is saying that it's not so much about only the external point of view, but more importantly, about like the internal point of view. And that was why I was trying to use examples from our constitution to illustrate that. Now, let's say the current situation we have in Ghana, it provides the perfect scenario for our reflection. Yes, we gave examples that the government needs House of Parliament to do so, to run the business of government, including loans, including living taxes and even budgetary, approval, allocations, appropriation of funds and all that. All these things, Parliament needs to pass laws before they can be done. Now, we have a situation where Parliament says, okay, we've adjourned indefinitely. We have not indicated when we are coming back. Can the government ignore Parliament and go about doing government business? And then you order the Accountant General to pay certain monies out of consolidated funds, contingency funds, and the various funds, when there is no reference to a particular provision of an Act of Parliament which has been passed to that effect. Now, if those officials are, for example, complying with the government orders, when the government has actually not wants to comply with the legal requirements, in that case, we cannot call those those rules which says the Parliament must meet certain rules, before you can do certain things, as actually having the force of law, because the officials and citizens don't consider themselves bound by it. So that is the point Hart is trying to make. But as it were, we haven't gotten to that stage yet, because even we can see how the ruling government party is trying to take steps to force Parliament to come back, as it were, so that it can get government business running, meaning that by and large, the officials and the citizens recognize the various legal provisions that we have quoted as something binding, and that is reinforcing the Hart's point of the internal point of view with respect to the rule of recognition.
Thank you very much, my lord. Thank you.
Any other question before we have our break? Yes, Godfred.
Good morning, my lord.
Morning.
And thanks for the lecture.
Thank you.
Please, I want to find out about the fact that society changes. I have to confess that I've missed some portion of the lecture. But I want to find out, when we talk about a society changes, are there parameters we can evaluate to come to a solid conclusion that yes, society has changed? For example, if we want to say Ghana has changed, are there parameters we can look at to come to a solid conclusion that yes, Ghana has changed? Therefore, there is a need for us to make laws, or there's a need for us to interpret the Constitution to reflect the change that has occurred. And the second question I don't know if I can go on to
okay, so let me react to your first question. I think your first question is a matter of sociology rather than law. Yeah, so as whether the society has changed or not, of course, it's also relative. It depends upon what you're talking about, because society is vast. There are so many dimensions of it. So if we are specific, then that is fine. But without even letting you give me any specific example, if you look at our society, if we come to even information, access to information availability, and all that, media freedom, press, and all that, society has changed. Now, every Ghanaian is a journalist in his or his own right, isn't it? You can just get any social media and you are preaching or publishing to the society, and people are following. So that is an example of a change. And not only that, as I said, there are so many dimensions of change which are discernible in society. So it depends upon what you are talking about. But otherwise, if you wanted to be more technical, then you need a sociological investigation. I wanted us to finish legal positivism. So Hans Kelsen, I want us to add Hans Kelsen before we go. So I am giving you just a 2 minutes break, and then we'll continue with Hans Kelsen. We just need about just